Seriously, if you don't know any other Supreme Court case as it relates to free speech on college campuses, this is the one to remember. How do you know when a college campus protest has gone too far? I'll explain to you what the laws are, at least here in the United States, and I'll tell you how I would handle these protests. At the moment, the big issue on college campuses is the war between Israel and Hamas in Gaza. And protests and demonstrations like this are not unusual. The law actually is designed to protect them to a very large extent under the First Amendment. But what are the limits of that protection? If you have deeper legal questions, nothing I say can substitute for the advice of your own attorney for your own legal situation. Generally, the laws on speech in America have to be content neutral. The U.S. Supreme Court has said that governments are allowed to restrict when, where, and how you can exercise your free speech rights, including petition and demonstrations and protests, if the regulation restricting your speech is justified under the Constitution, if there's a substantial governmental interest behind it, meaning they're not just restricting you for some petty reason, if the interest is not related to suppressing your free expression, and if they only restrict it just as much as is necessary to further that government interest. Just because you're a student on a college campus, that does not mean you give up your free speech rights, especially if you are at a public college or university, which is a government institution. The court dealt with this back in 1972 in the case of Healy versus James. It had to do with a left-wing student organization called Students for a Democratic Society that was trying to organize at a state college campus in Connecticut. In this ruling, the U.S. Supreme Court echoed an earlier ruling about free speech on school campuses, Tinker versus Des Moines, back in 1969. Students nor teachers, quote, shed their constitutional rights of freedom of speech or expression at the schoolhouse gate, unquote. Part of this is because schools are sort of a laboratory of democracy. They're where you learn how to be a citizen. And if we want you to be able to be a citizen who understands free speech rights when you're fully an adult, we got to start you young. Now, to be clear, this did not mean that student organizations on state college campuses could do whatever they wanted. Far from it. In the Healy ruling, the court did say that colleges and universities could prohibit activities that would, quote, infringe reasonable campus rules, interrupt classes, or substantially interfere with the opportunity of other students to obtain an education. This has also come up in cases that involve religious organizations that want to practice their faiths, like this one group in New Hampshire of Jehovah's Witnesses. In the case Cox versus New Hampshire, they sued a New Hampshire town for trying to set regulations on the ways and the places in which they could hold their religious activities, but the Supreme Court ruled against the Jehovah's Witnesses. This established the concept of time, place, and manner. That's the key to a content-neutral regulation. For example, suppose that you wanted to hold a protest on Main Street and Fifth Avenue in any town, USA. But on Main Street and Fourth Avenue, there's an elementary school, and it lets out a half hour after your protest is scheduled to begin. We have to figure out how to get the kids out of school, how to handle the traffic of the school buses, when to notify parents so that the public doesn't interfere with the protest, and so the protest doesn't interfere with the public, and everyone can get what they need. Back in 1992, the U.S. Supreme Court ruled on the matter of a group that wanted to protest the Martin Luther King Jr. federal holiday, and the county where they wanted to do this, Forsyth County, tried to set different kinds of fees for different kinds of speakers and different kinds of events. The Supreme Court ruled that that was not okay, that public accommodations have to be accommodating for various types of groups and organizations who want to use government facilities, public facilities, to use their First Amendment rights. Now, all of this so far has had to do with public accommodations, like public universities and public colleges. Check out the law in California. This is called the Leonard Law, and it sets additional requirements on private institutions. The Leonard Law basically says that if a public institution would protect a certain kind of First Amendment expression, private institutions in California have to do so too, and they cannot punish students for it uniquely. Again, this is just a law in the state of California. Whether it applies to other states, that I don't know. You'll have to do that research on your own. One of the big issues that's come up on college campuses is how competing groups of protesters deal with one another, particularly when one group shouts down the other group. There have been a number of incidents on college campuses where Jewish students were beset by a mob of other students, presumably not Jewish, but maybe even not from the university. And those students were the targets of harassment and shouting and screaming and yelling, and they basically just kind of had to flee. That is a heckler's veto. When you shout down someone else and prevent them from using their First Amendment rights as a private citizen, which you are if you're a university student, the law does not protect that. I want to pause right now and speak to those of you who are getting angry with me because I told you not to shout someone else down. Your anger, your feelings, your pain, your rage, your fear over what the future looks like for your cause, those are all valid, but do not expect this particular area of the law to bend for you. On top of that, nobody wants to listen to you scream. If screaming was effective, I'd say go scream, but you have so many other options. I don't understand why that one looks like your best choice. And I'm going to give you a better choice nearer to the end of the video. There is a long list of forms of speech that are really not protected or are only slightly protected by the First Amendment. The most easily restricted form of speech when it comes to protests are anything that are likely to and intended to cause immediate violence. That is a big no-no. This came up in a case called Brandenburg versus Ohio. It had to do with a Ku Klux Klan rally. Seriously, if you don't know any other Supreme Court case as it relates to free speech on college campuses, this is the one to remember. Clarence Brandenburg was a Klan leader, not a nice guy. He said some things at a Klan rally in Ohio that got him in trouble under state laws. Among other things, we're not a revenging organization, but if our president, our Congress, our Supreme Court continues to suppress the white Caucasian race, it's possible that there might have to be some revengeance taken. Rings like Shakespeare, don't it? Well, the state of Ohio convicted Mr. Brandenburg under the Ohio criminal syndicalism statute, and that got struck down by the Supreme Court. They ruled in the Klan leader's favor. Even hate speech is protected. The standard the court set was for speech that is intended to produce imminent lawless action, like violence, and likely to produce that action. This gets to another big issue that comes up on college campuses where you'll have advocates for Israel and advocates for the Palestinians looking at each other basically nose to nose and saying amazingly harsh things to one another. Just because they're going at it and they're yelling and screaming and cussing and fussing does not necessarily mean that violence is about to break out. However, the court will also regulate speech if it is what's considered a true threat. That means whoever said it meant to put someone in fear of bodily harm, whether they intended to hurt them or not. See, it's one thing to yell death to whomever, but if whomever is standing right there and you're looking at them and the mob goes, yeah, and rushes for them, nope, you're out of bounds. Why would you do anything that would get in the way of people hearing you out? What results are you getting for your protest? Have you persuaded anyone? Have you moved anyone? Have you changed any policy? Do you have any wins to show for your efforts? Or does the death toll continue to rack up in the Middle East and you continue to feel disconnected and powerless? If it's not working, why do it? I've covered a lot of protests and a lot of demonstrations, and one of the things that I have found that moves me the most as a journalist is talking to people who are level-headed enough to have a conversation, but also vulnerable enough to share their pain with me. And I think that's the actual issue. See, I think when you're in pain, anger is a very convenient shield to mask those apparent weaknesses. It can make you feel stronger than you would if you were kind of crumpling in on yourself and just crying all the time. And I understand that, right? I don't want you to get out on the quad at your college or university and just fall apart in a heap when you've got something important to say. I want you to say it, but maybe that's something to examine inside yourself, is whether or not you are using anger and intense physicality as a shield, as a smoke screen for your own pain or fear or, God forbid, shame. And instead of dealing with it, you're taking it out on other people. If you would take out your emotions on other people, how can they possibly trust you? I have found that your best bet, if you want to do this, is to stick with speech that tends to be more protected by the First Amendment. Art. I'd be making art, See, the beauty of going to an art gallery is you look at the same piece of art next to someone else and it immediately sparks a conversation. Persuasion begins with engagement. And if you are so loud in your initial engagement, other people are going to walk away because they generally don't feel like being that loud with you. That's how you start a fight. But if you start softly, then you give a conversation somewhere to go. It's a lot easier for me to imagine the value of talking to you. And then you know that the people who are talking to you about what you've done, they want to hear you out because you've enticed them to be curious about what you have to say. Let me know in the comments if this was helpful, just walking you through some of what these laws are. You should speak to a First Amendment lawyer for detailed advice if you have questions unique to your situation. And whatever you're advocating, don't lose hope. Believe it or not, it actually is still possible in this country to make a difference. But the best way I've found to make a difference is to be different. The best way to make a difference is not just to scream so that everyone hears you, but to bring something different, so that people approach you and say, hey, what do you have to say? That's what really makes a difference.